Can legislation in California affect pending litigation? Sometimes a question is raised about the impact or potential impact of legislation that's pending in the California legislature that could affect pending litigation in state or federal court. Now, as a general rule, and it's not a formal rule, so we refer to it as a custom and practice, the legislature in California generally prefers not to enact legislation that specifically takes sides or makes a determination one way or the other regarding pending litigation. Now, nonetheless, there are times when the legislature specifically intends to resolve a legal dispute by enacting legislation. In either one of these cases, it's an appropriate policy avenue for the legislature to take as the elected representatives of the people. Moreover, it's a perfectly lawful approach, as Article 4, Section 1 of the California Constitution grants the lawmaking power to the legislature. Now, part of the decision to be made by the legislature is whether to apply this law change only prospectively or also to apply it retroactively. Statutory changes made by the legislature are almost always applied prospectively, unless they're intended to apply retroactively. In either one of these instances, the state law change can affect pending litigation. And both the US and California Supreme Courts have determined that if certain criteria are met, that law change can in fact affect pending litigation. For example, one of the main federal court decisions as a precedent is Landgraf versus USI Film Products, a 1994 decision of the US Supreme Court. Here, the federal high court said that first, look for an unambiguous directive from Congress, which would control the outcome. In other words, did Congress specifically state that the law change applies to pending litigation? The second approach is to review the language and determine whether Congress intended that statute to apply only to future cases. If that intent is found, then the judicial inquiry ends. But where there's ambiguity, the federal courts and California courts as well want to ensure that any vested or substantive rights are not adversely impacted or affected by that legislation. Substantive rights are distinguished from procedural rights in this judicial review. Now, the US Supreme Court's decision in Landgraf also listed additional protections against retroactive statutory changes, such as those found in the the United States Constitution, including the ex post facto clause, the contracts clause, the takings clause, the bill of attainder clause, and of course the due process clause. In addition, about 10 states actually have state constitutional provisions that expressly prohibit retroactive state law changes. However, California is not one of those 10 states. On other occasions, the California legislature prefers not to impact litigation. For example, in Vehicle Code Section 11754D, it provides the changes to this section made by this act, adding subdivision C, shall not apply in any manner to pending litigation. We find something similar in California Insurance Code Section 116.6 that provides in subdivision F, nothing in this section is intended to affect any pending litigation. So as a result, you can hear that the legislature can choose to make a statute operate prospectively or retroactively, as well as impact pending litigation. The key is whether there's a clear statement in the statute to do so. Similarly, the legislature can expressly decide not to impact any pending litigation with its statutory changes.